Hey guys, welcome to Probate Café for another episode. And just want to share with you who we have today as our special guest. We have Samantha Smith, who is with NM Law, and she specializes in probate cases as well as trust administration and trust litigation. So welcome, Samantha. Thank you for joining us.
Thank you so much for having me.
Oh, you're welcome. You're welcome. I'm ready to jump into these questions that I have for you. So I'm ready to share a lot to our audience and how they can possibly navigate the avenue of probate and or trust administration and so forth. So
Awesome.
what type of cases do you handle?
So we handle probates, which is where somebody passes away not having a trust in place, not having their assets in a trust. We will also handle trust administration, which is either post the creator of the trust becoming incapacitated or passing away. The trust will need to be administered, so we'll represent the trustee in that situation. And then trust litigation as well, claims of financial elder abuse or claims to try to invalidate the trust document based on undue influence and claims like that.
Oh, fantastic. What's your typical client? Like what type of person or what's their situation?
Usually our clients are executors of a will, somebody who is nominated as the executor and who has the duty to administer the estate when somebody passes away, or a trustee of a trust who is nominated in a trust document and has to usually administer the trust once the trustor passes away. We also represent trust beneficiaries when they have claims that they want to bring against the trustee or to challenge the validity of the trust document.
Interesting. It sounds complicated.
Not too complicated, a lot of fun. It's kind of I like to call it inheritance law. So anything to do with inheritance, then that's where your people.
Fantastic. Well, speaking of trust, but what about, share a little bit about probate. Is probate necessary, and if so, when?
Yes, so probate is necessary. Usually it's when the assets of a deceased person are outside of a trust and the value of those assets exceed a value of $184,500. So I kind of round down and usually call it $184,000. But if you have certain assets that are held in joint tenancy or like life insurance or a IRA or 401k where you have a beneficiary designation on file, then those assets can usually stay outside of that probate threshold amount. So what we'll do is we'll talk to the person who is either executor in the will or a deceased person's child or other heir, and we'll kind of make a determination on what assets that they have to transfer and determine which assets we could keep out of probate, and then those that might have to go through probate, we'll make a determination if it's necessary or not.
Oh, okay. Yeah. It sounds complicated as well when someone has or they hold title to the property in joint tenancy, right? Because a lot of times if someone passes, will that other joint tenant or that joint tenant, the decedent, will they have to go through probate based on their ownership?
So usually with joint tenancy, you're going to be able to avoid a probate because the surviving joint tenant will become the owner of the property upon the deceased joint tenant's death. And there's some risks in holding title in joint tenancy. So I've had clients before where one spouse becomes incapacitated during their joint lives together, and in that case, it's not a probate situation that you need, but that involves now a conservatorship situation. So the safest way to own property is usually to hold title in the name of a trust.
Oh, fantastic. Okay, I see that a lot myself, and it's I kind of say this quite a bit as well as on my show is. Only about 20% of the population that own homes have their property in a trust. So anybody listening, watching, reach out to Samantha if you need to set up your trust because it's really important. You just don't know when that day is going to come and you want to be prepared. So they should definitely reach out to you. And we'll post her information later and you can reach out to her for any needs you have.
Thank you.
You're welcome. Hey guys, thanks for watching. If you like the information you're listening to, please feel free to like, comment, and or share the video and or podcast wherever you see it posted. Greatly appreciate it. Thanks so much. And share a little bit about when someone's going through probate. Obviously, sometimes they need to be bonded, right? The administrator, executor. What is a bond and why would it be required?
Yes, so bond is kind of an insurance policy that the executor of the estate will oftentimes have to post. They obtain this bond from a surety company, and the bond value is determined and calculated by the assets that you're bringing through the probate. The purpose of the bond is to basically protect the estate and the estate beneficiaries from any malfeasance by the executor or the administrator of the estate. I always give the example when I'm talking to people, if the administrator of the estate were to sell the home and cash out the cash and move out of the country, what recourse do the beneficiaries of the estate have? If there is a bond in place, and sometimes it's not required, oftentimes we ask the court to waive bond because it does save money for the estate and the beneficiaries of the estate. So, but if that malfeasance does happen, then the beneficiaries of the estate can make a claim to the bond company, and the bond company will pay them to make them whole. And then the bond company has a right to go after the administrator for indemnification, which just means collection against the administrator of the estate.
Oh, interesting. So it protects everybody, essentially.
Yes.
All the beneficiaries additionally. Okay.
Beneficiaries and creditors.
Oh, interesting. Okay. Interesting. All right. Well, when we're talking about creditors and also, basically a will, what's the main difference between a will and a trust?
Yes. So a will is a document that does not keep you out of the probate court. It is a person's written instructions as far as who they want to be the administrator of the estate and how they want their assets administered and distributed ultimately. A will is not a self-administering document. You have to file an original copy of the will with the court to authenticate the document and admit it to probate. And then a probate is a fully court-sponsored, court-authorized proceeding, which usually takes about 12 to 18 months to get through from start to finish. And usually you want to try to avoid the probate court because of that very long delay that you have in completing it. And the cost of a probate is probably 3 to 4 times more than putting together a trust. A trust is a similar type of written document where the person who creates the trust writes down who they want the trustee to be, who they want the beneficiaries to be, and what they want to receive or what they want them to receive. But a trust is a self-administered document or can be administered outside of the court. So the trustee simply, if the creator of the trust passes away, the successor trustee picks up the document, reads the instructions. Basically, it's kind of like a contract, kind of like an owner's manual, and starts taking action to administer the trust and doesn't have to involve the court usually.
Okay. Now, a question for you. A will, you really need a will and a trust, not just the will, right?
Yes. Yeah. When you have a trust, you still want to have what's called a pour over will. And I call this the oops document because a lot of people will put their house in the trust, but maybe leave some bank accounts outside of the trust. Or sometimes we put our house in the trust, but then we get a refinance. We refinance the loan, and the house has to come out of the trust usually in order for a lender to give a new loan on the property. And a lot of times we find that the owner of the property will not put the house title of the home back into the trust after they get the refinance. And sometimes at death, we'll find that even though they had a trust, it's empty, right? They didn't have any assets in there. So the pour over will really helps to collect or direct, I should say, any assets that are outside of the trust at the decedent's death into the trust so that the terms of the trust can control the ultimate disposition of those assets.
Okay. And this is kind of an interesting situation. For example, there's a will, someone passes away, but before, when they're planning their estate, should they make copies of that will? Because we run into situations where someone will sometimes attempt to write in a new will and create something different without the other beneficiaries knowing about it.
Right.
So how does one how can they protect themselves in that situation?
Yeah, that's a good question. I've had good and bad. I've seen it both ways, right? I've seen cases where somebody has created a trust or a will and didn't give copies of it to their kids, but put the original will in a safe deposit box. Never told their kids or anyone else where the safe deposit box was. Didn't tell them, give them a key or anything like that. Didn't make them a joint owner or a person that can access the safe deposit box. And we've had original documents lost that way because then, mom or dad lose capacity, they get dementia or Alzheimer's, and then, this original document is missing. Sometimes you can contact the person or attorney who created the document if they're still living, if they're still practicing. and the successor trustee or whoever is the executor is able to obtain a copy of the will that way or the trust that way. But an original will, specifically a will, has to be an original in order to lodge with the court. If you don't have the original will, then there's other ways you can try to open a probate. You have to have one of the witnesses of the will sign a declaration. But I would say the best practice of what I would do is to let the successor trustees know where the original documents are, if they're in a file cabinet in your home or a safe. I don't like safe deposit boxes because keys go missing and people forget where they are. I do like, maybe a home safe or a file cabinet. And then, yes, keep electronic copies to your successor trustees, or, if you know that all your kids are going to get along for the rest of their lives and through your death, then give it to all your kids. Or if you have somebody who's more trustworthy, then that's who I would entrust with something like that.
Okay. And then when someone's appointed executor of a will, what are the next steps typically?
Yes. So, executor of a will, the next steps are basically to, start the probate, if a probate's required or necessary, I should say. A probate is only necessary if you have assets that exceed that value of $184,500. If you need to bring those assets through probate, so usually anyone with a home, right? That the homes in California are always going to exceed that threshold limit. And so the first steps is to file the will with the court, file your petition. The court sets a hearing date, and then you go to your hearing date in about 3 to 4 months from the filing date and hopefully get appointed on that date. And then you need to get bond unless bond is waived. There's a probate referee who's assigned by the court, and the probate referee is responsible for giving a value of most of the assets, like real property. A probate referee would give you that date of death value. A few other steps: you have to give notice to creditors. The IRS, the California Franchise Tax Board, the Department of Healthcare Services, all are 3 required entities that must get notice in a probate. So those guys got to get notice, and then any other creditors are out there, such as like a credit card company or a medical providers. Oftentimes will have claims, and those creditors have 4 months to make claims. 4 months from the date the person is appointed as the administrator. And then after that, you can work to close up the estate. You've got to file another type of petition, and another hearing date is set on that. And then eventually your whole goal in the probate is to get an order for distributions. And
Gotcha.
so once you have that, then you can distribute cash, property to where it needs to go.
And that takes a while, I'm sure.
Yes, I would say at least 12 months is a minimum probate. Because if you think, to get somebody appointed, it's about 3 to 4 months. Your creditor claim period is about 4 months. And then after you file your second petition, it's another 3 to 4 months waiting period for that. So usually I tell people, my fastest probate, and this is pre-pandemic, was 12 months.
Wow, that's the fastest.
Yes. I would say usually they're about 18 months or more.
So you don't want to go through probate. That's the thing. It's going to stall everything.
It does stall everything. It's really problematic for people with reverse mortgages, because in a reverse mortgage situation, as you may know, the lender wants to get paid right away after post-death. So if you have this delay in getting somebody appointed who has the authority to sell the property or obtain a new loan and refinance the property, the home is losing equity every single day. So I always advise people who have a reverse mortgage to make sure you have your property in a trust, just to cut down on those delays and save as much equity as you can.
Yeah. And kind of what we see out here in California, a lot of elderly will own mobile homes as well, right? So does that fall under, obviously it's personal property unless they own the land, or affixed to the land, then it's probably real property. Right. But personal property, that also is involved with that threshold of the 184, right? Is that part of that?
Correct. Yes.
Okay. And most of the time it will be over that, even if someone does own a mobile home.
Right. Yeah, I brought a few mobile homes through probate. I have one right now. It's about a $280,000 mobile home. That's the only asset that we have. And that is has to be brought through probate, and it's just personal property. That's correct.
Wow, so a lot of people probably don't understand that as well. It's not just a house. You can have a mobile home, and even if you're leasing the land, that still could be a part of, it could be an issue and have to go through probate.
Correct.
So anybody listening that owns a mobile home, again, reach out to Samantha. She'll take care of you, because you don't want to go through that issue.
Yep.
Well, now, what about trust? As far as a trustee, what are the first steps someone should take if they're a trustee and someone has passed?
Yes. So a trustee, it's similar steps. It's a lot easier. My favorite type of case I tell everyone is a trust administration, because I love representing a trustee where there's, just a trust document to follow. We advise the client on what they need to do, and then they take those steps, and they're usually in and out with an attorney's office pretty quickly. You don't need a lot of attorney help to be a trustee administering a trust, usually, unless there's like disputes or weird things. But a trustee basically usually needs to retain an attorney, just to make sure that they're reading the trust correctly and taking the necessary steps. There's a required notice under the probate code that a trustee needs to get out as soon as possible to all the beneficiaries and all the people who are related to the decedent that may not be beneficiaries, even if they're like disinherited in the trust document. Like a child who's disinherited still needs to get this notice that they've been disinherited by this document and a copy of the document, because this notice starts a very important time period. It's 120 days in which challenges to the validity of the document can be brought. And so you want to start that 120-day time period as soon as possible, because the last thing a trustee wants to do is start administering a trust, selling assets, distributing assets, get everything out of the trust. And then lo and behold, there's this disinherited heir out there who, doesn't believe that that's the trust or the trust creator's signature, right? Or they believe that they were coerced into signing that document. So that's one of the most important things. And then after you get that notice out, my next step is always a date of death inventory. The sooner you can get that out, in my experience, to the beneficiaries who are entitled to receive it, the better, because the beneficiaries feel more comfortable with what the trustee is doing, right? You're giving them information, which the trustee is required to do under the law, but the information is, this is what mom or dad or grandma died with. These are the assets. Here's the bank account statements. I have to sell a home. You give them sort of you give them a roadmap on what they can expect. And that communication right there really helps lay the initial groundwork for a smooth trust administration. Because otherwise, if the beneficiaries don't know what the trustee is doing, there's all this sort of mystery involved, then suspicions arise, and, then we have disputes. And a lot of those sort of family relationships or dynamics are really hard to mend if they're not off on the right foot right away. So that's what I always recommend to my trustees is, get your notice out, get your date of death inventory out, and then, work to marshal the assets into the trust, sell assets, and then, provide an accounting. And then once you provide an accounting, you should be able to distribute.
And you help your clients through that process, because a lot of people, they've never been in that situation. So it's always good to work with someone like yourself to assist them through that.
Yes, definitely. We usually give them a roadmap and say, coach them at the very beginning. And a lot of my trustee clients can handle a lot of this on their own. If they only have one brother, for example, or one sister, and they're both on the same page, an attorney's involvement can be very limited. A lot of times, though, if there's 20 beneficiaries and some are charities, and if it's a larger trust, then you're going to need an attorney for a longer period of time to help you complete the administration in a way that protects the trustee. That's really the attorney's goal or role in the whole thing, is to make sure that the trustee is protected from liability claims that they've damaged or breached their duties, damaged the trust or breached their duties.
Interesting. Mm-hmm. And how about, does that trust need to be filed with the courts, or a will? Does that need to be filed, or? Yeah,
good question. I always get that question from a lot of clients where they let me know that, dad had a trust and it had to been filed. It had to been recorded. And trusts are revocable, right? Most people's trusts, like a family trust, that I would say 75% of the people who create trusts are creating a revocable trust. It's not recorded or filed anywhere during the person who creates it lifetime. Very rarely, even post-death, is a trust going to be recorded. Maybe if it's an exhibit to a document that has to be recorded, but no, trusts are not recorded. They're not filed anywhere. If you have to involve the courts for any sort of trust matter, then the court is going to want to see the trust. You file it as exhibit to your petition. But a will, the original will, has to be lodged with the court, or if you don't have the original, a copy has to be filed with the court. And that's really it. So
Oh, interesting. Okay. What about conservatorships? This is a whole different area. Well, is it a different area? I don't know.
yeah, so conservatorships is something that we handle as well. It's within the probate court. So in addition to probate and trust litigation that you would be in probate court for, conservatorships and guardianships are within that realm as well. So a conservatorship is just a proceeding where somebody who lacks capacity needs some other person to be appointed to help them manage their daily living needs and healthcare decisions, and also their finances. So that we can help with conservatorships as well if any of the listeners have questions about that.
And then here's a question that contested and uncontested conservatorships. What is kind of the difference there?
Yeah, so a lot of times a conservatorship is uncontested, which means that, everyone in the family agrees that mom needs a conservator, right? She has dementia, and there's no question or there's no dispute as to mom's need for a conservator. And everyone in the family would agree that, okay, my sister should be appointed as conservator because she is with mom, she lives with mom, or lives the closest to mom. And so there's no dispute as to whether mom needs a conservator and who should be the conservator. That's an uncontested conservatorship. It's the easiest type to get because it's a pretty streamlined procedure. Upon filing with the court, somebody gets appointed. There's some post-appointment things to do. Contested is where there's a dispute as to whether, the parent, the incapacitated person, needs a conservator, or who should be appointed as conservator. And we do both. I would say the most common type of contested conservatorship would be like competing petitions for conservatorship, right? For example, mom needs a conservator. There's no dispute as to that, but both brother and sister, son and daughter, want to be the conservator. So each file a petition, and then the court's going to want to send a trial on those petitions to make a determination as to who should be appointed.
And that's where you kind of go to court and fight for your client on that.
Yes.
In that regard, because it could be someone else could be trying to get conservatorship because maybe they live with them, maybe they're in charge of funds and things like that, right?
Right. Well, we usually see there's, good motives and bad motives, right? So a lot of times people want to have a conservatorship because they want to protect mom from another child trying to take advantage of mom. Or maybe it's not a child, maybe it's the credit card companies who are trying to take advantage of mom. But everyone has their own opinions. Everyone feels, different. That's when you're going to end up in this sort of contested conservatorship realm. And it's it can be quite long and an ugly battle to go through.
Yeah, sure. And as far as when you're talking about creditor claims, things like that, what type of claims do you assist beneficiaries with when they're bringing, a claim against either a trustee or a trust?
Yes. So creditor claims are usually going to be involved with like a probate. So usually once a creditor makes a claim, an executor or an administrator of an estate only has about 30 days to allow or reject the claim. And if they fail to respond within a certain time period, then that creditor can file a lawsuit, and a hearing would be set on that petition, and then the court would make a determination. And so with regard to trustees, any sort of claims that would be brought against the trustee would just, make a determination as to whether it's a valid claim or, whether it needs to be dealt with in any certain way.
Okay. And then when you're speaking about trustees and what they do, what's a reasonable compensation that they should pay themselves, or how do they get paid, and what is all that about?
Yes, very good question. Trustees are usually paid per the trust document. So the trust document can allow for compensation. I just saw one today, actually, that said 20% of the net assets that are in the trustee can be paid 20%. That's the largest number I've ever seen. I think that's a little, very, very high. Here in Orange County, California, the going rate for trustees is usually 1% to 2% of the assets under management. Most trusts that you see are going to say reasonable compensation, right? The trustee is entitled to reasonable compensation, and reasonable is kind of defined by the case law and then the area in which you are practicing. So that's why I said in Orange County, it's anywhere between 1% to 2% of the assets that are under management per year. So, if a trust has, $500,000 of assets, then anywhere between 1% to 2% of those assets will be paid to the trustee per year. So if you're administering the trust 2 years, it could be 1.5% of 500,000 for the first year, and again for the second year.
And so when we were talking about the kind of the support and help you provide beneficiaries, if they see and they look at a trust and it says, 10%, the trustee to be 10% paid 10% of the assets or 20%, like you said, is that probably a situation where they would reach out to you and you would maybe have to go to court for that, right? If there's multiple beneficiaries, because they just want to make sure they're looking out for everybody's interest, right?
Yeah. So if the trust document says 10%, or like the one I saw today, 20%, the trust is a contract. So in that case, the trust is going to control. Usually the trust is going to say reasonable compensation, as I mentioned. If the trust is silent as to compensation, the California Probate Code says reasonable compensation. So it's very different. Trustee compensation is very different from a probate attorney's compensation or an executor's compensation, which is set specifically by the California Probate Code. And that's a sliding scale. For example, it's 4% of the first 100,000, value of assets, 3% on the next 100,000, and 2% on the next 800,000. So basically, for an estate that's going through probate, that's worth 600,000. Your minimum attorney's fees is 15,000, and then your administrator of your estate, who's represented by the attorney, they're also entitled to the same amount of compensation. So that's $30,000. 15,000 to the attorney, 15,000 to the administrator, right off the top of the probate estate value. And that's another reason why you want to try to avoid probate by putting your assets into a trust.
Oh, for sure. And then the trust can decide where that property goes at that point, right?
Yes.
And then you forgot, if they need to sell the real property, then you've got realtor fees on top of that. So that it could be a huge loss to someone just not setting up a trust.
Yes.
Right?
Yes. That's another good point, though, that usually a client, an estate beneficiaries and the administrator, they will be forced to sell the property if it's not in a trust, because you have to pay creditors, you have to pay the attorney who represents you, you have to pay CPAs and a tax preparer to prepare taxes, and unless the estate has other cash assets or other assets to sell, and I would say probably 70% of our estates have just real property, and if there's just one real property and the beneficiaries or the kids of the deceased person want to keep the real property, they have to actually advance money into the estate a lot of times in order to pay these costs of administration if they want to keep the real property. I have a case like that right now where, there's probably 5 children and there's just one home, and they want to keep the property and just have the probate court say, okay, distribute out in 5 equal shares. We'll all be co-owners of this property. And so in that case, they've had to advance our statutory fee, what we would have been paid had there been a sale, or had there been liquid cash to distribute. And so they advance that sum into our attorney trust account. We still have to get the court order that authorizes the payment. But having that in the trust, if that property was in trust, they wouldn't have to have, this sort of required sale or this required advancing sums into the estate in order to help them get through it.
Yeah, another reason why you want to set up a trust right away if you don't have one, or if your parents have lived in their home forever and it's paid off, that kind of thing.
Definitely.
Because it'll just cause a lot of hardship if you've got to front money to pay off creditors anyway, and you do want to keep the property.
Definitely.
Or if they live there or something, I'm sure. Yeah, so anybody listening, again, as always, reach out to Samantha. Set up your trust. It's really important. And if not, you're going to have someone probably managing it that you probably don't want to manage it, and you never know what fees they could be charging or what could be written in, right?
Right.
If you go to a kind of a fly-by-night service or something like that, where you don't know how it's put together until it's too late.
Right.
Right. And can they also reach out to you to do a trust review? Is that typical?
Yes, that's a good question. We also we offer a free trust review, so we will look at the documents that some people have already in place, make a determination as whether the documents could or should be amended. The probate code had a pretty substantial change in 2011. And so if your documents were prepared prior to 2011, it's a really good idea to have them reviewed just to make sure that your trust document is still acting in a way that you want it to, and that it's still there in a way that is beneficial to you.
And I think we talked about this a little bit, but what type of documents need to be provided to beneficiaries of a trust?
Beneficiaries of a trust are entitled to the trust document, first and foremost. They're entitled to an accounting of all of the transactions that the trustee has done from date of death to the present, right, or until distributions are made. In addition to the accounting, which is basically a summary of all the transactions, the beneficiaries are entitled to all the supporting documents. So, bank account records, copies of checks, invoices paid, billing statements, everything that the trustee has used to create the accounting, tax returns, a lot of times the beneficiaries are entitled to, just to verify that the trustee's accounting is accurate and complete. So those are the type of things, a lot of times we'll represent beneficiaries who haven't received anything from the trustee. The trustee is not represented by counsel, and they're telling the beneficiaries, basically go pound sand, right? No, you're not entitled to that. No, I'm not going to give you that. In that case, then we will represent the beneficiary to make a demand to the trustee for an accounting. And trustee has about 60 days from the date of a written demand to produce an accounting or the records that would substantiate the accounting.
And that's kind of leading into my next question is holding the trustee accountable, right, for the beneficiary's interest. How does that, I guess you just explained a little bit about that, but is there any more to that?
Yeah, so the only way to hold a trustee accountable is get them to voluntarily provide you the documents that you're entitled to as a beneficiary. So we usually will write a demand, like I mentioned, and see what they give us. But a lot of times the trustees will not cooperate. And you can write letters to the trustee, till you're blue in the face. Mm-hmm. And they can simply say no or delay. And in that case, the beneficiary's only recourse is to file a court petition against the trustee. The benefit of filing a court petition is subpoena power, discovery power. We issue subpoenas directly to the banks, directly to the medical providers, get copies of the records that we need to prove that the trustee has caused some sort of damages, monetary damages to the trust. And in that case, that we'll review the records and, make a determination. The courts are also there for a beneficiary's protection. The court can suspend a trustee or remove a trustee for breaches or causing damages to the trust. So those are the types of things we can help with if a beneficiary is not getting, reasonable information in a timely fashion from the trustee.
And in that situation where the beneficiary wants to bring, claim or suit, can the trustee use the funds of the trust to hire an attorney to defend themselves, or?
Yes. So as long as the trustee is acting in the best interest of the trust and in furtherance of administering the trust in a proper legal manner, then the trustee has the authority under the law to use trust funds to retain a trustee counsel, an attorney who represents them in the capacity as a trustee. Now, usually a trustee is also a beneficiary of a trust. So there's this split that the trustee cannot use trust funds to represent their own personal interest in the trust. So a lot of times we'll be representing a trustee and the trustee will want to make a buyout offer to another beneficiary. But we have to advise them and coach them and say, we can't represent you in this offer. We can maybe present a first offer from you as a trustee if it's in the best interest of the trust. But if there's any negotiation further than, that goes further than this first offer, or if you need to have an attorney, spend any more time than making a first proposal, then the trustee, who's also the beneficiary, has to retain separate legal counsel to represent them in that capacity as a beneficiary. And so that is a area of concern of ours when we're representing beneficiaries. We will usually include in our petition that if we have to file with the court, a demand that the trustee is not able to use trust funds to defend our petition, right? If we brought a petition to either invalidate the trust document or make claims that the trustees damaged the trust, we want a really early court order that says, trustee, you are completely, disallowed from using trust funds.
Wow, that's smart.
Yeah.
Nice.
That's the goal.
Yeah, well, you always want to do the best for your client. So,
Yeah.
and we talked about trust, and we talked about probate, and a lot of times I see what we see, in the court filings is pro per, right? Somebody's going to go through the process of probate themselves because they think they can do it, they think they're going to save money,
Right.
and I always see that backfire, and they always usually end up hiring an attorney. Right, just because there's beneficiaries that want their money, they want it sooner than 3 to 5 years, basically, because that's what it could take.
Yes.
I see that a lot. So if you're in a situation and you filed pro per and you want to handle it yourself, again, reach out to myself or Samantha. She'll take good care of you, and it'll drive you crazy if not, and you'll hopefully, she'll help you out with the beneficiaries because I'm sure they're going to be knocking on their door or your door and wanting to know what the status is and where's their money and all of that, right?
Yeah, I mean, I've represented a lot of clients who would try to do it on their own, and then they'll come to us and say, I can't do this anymore. My sisters think I'm doing everything wrong, or they think I'm doing something I'm not. And when we usually take over in that type of situation, they will always tell me that it feels like a huge weight is lifted off their shoulders, because now I'm the interface into the with the beneficiaries. We know the right things to say because we do this day in and day out. We know the things not to say. We know exactly what to provide in order to, address their concerns, the beneficiaries' concerns. And usually we will, be able to resolve that situation pretty quickly, especially if there's counsel on the other side. If the beneficiaries are able to get counsel, then we're able to work with the opposing counsel, and that's usually preferable. It's harder to represent somebody, or it's harder to resolve issues with people who are in pro per because they're not understanding the law. They're not understanding the potential liability that they may be facing.
Sure, yeah, and even just going to court, right? There could be probate notes by the judge and things like that they don't understand and they didn't prepare for, that it just drags on. And just it can be, I'm sure it can be a complete nightmare, right? And
yes, probate notes are what you want to clear right away. So if you've ever gone through a probate, the court is going to issue probate notes, and you have to clear those in order to get your petition approved. So when we represent anybody in a probate, we have these automatic reminders to check the probate notes, because unfortunately most courts don't tell you when they issue probate notes, but you have to find them. You have to be diligent and be checking the court's website. And we find these probate notes, we prepare a supplement right away. Our goal at our firm is no continuances, right? We want to clear these probate notes and just have one hearing if we can help it. Sometimes there's things that are out of our control, like a court staff will not get to review our petition until 5 days before the hearing, in which case there's not too much you can do about that. So, but like I said, you clear your probate notes, and then you have sort of the green light, and you're welcomed with open arms into the approval zone. Right.
Well, you shared a lot of information today. It's been great. It's been
Thank you.
From trust to probate and the whole 9 yards. So I think hopefully I definitely learned something new each time, every episode. Hopefully our listeners have as well. And again, how can people reach you what's your best way to be contacted?
Yes, so you can reach me at NM Law. We're located in Tustin. Our phone number is 949-253-0000. And my website should be on our website as well. And I can rattle that off if you think it would be helpful. Okay. It's S. Smith, so S for Samantha, and then my last name, SMITH, at mintocounselors.com. Minto is spelled MINTO. Counselors is COUNSELORS.com. Thank you so much for having me. This has been a lot of fun.
Yeah, thank you for joining us, and look forward to the next time.
Thank you.
Guys, thanks for watching. As always, keep posted for our podcast for our next episode. And if you do need any kind of representation and legal services, feel free to reach out to Samantha, and she'll take great care of you. Thanks for watching. We'll see you on the next episode.